Good afternoon and welcome to today's panel on contracts and the relationship to other doctrines. My name is Trey Nazzaro and I'm the editor-in-chief of the St. Thomas Law Review here at St. Thomas University, and I will also serve as your moderator today. This panel reinforces the importance of contract law and theory and how it can apply in many different areas of the law. With me today are panelists who will discuss how contract law can be used in the context of constitutional law, property law, criminal law, trust law, and family law. Professor Jamie Fox will be up first, discussing the connections between long-term contracts and constitutional interpretation. He received his JD from the University of Michigan and teaches American legal history, contracts, and poverty law at Stetson University. Professor Juliet Moringiello will talk about property law and contract law in the context of bankruptcy cases. She received her JD from Fordham University School of Law and her LLM from Temple University. She teaches bankruptcy, property, sales, and secured transactions at Widener University School of Law. Professor Roni Rosenberg will analyze contract law in the context of finding criminal liability based on a contractual duty to act. He received his LLB, an MA in philosophy, and a PhD in law from Bar Ilan University in Israel. He's a member of the law faculty both at Bar Ilan University and Carmel Academic Center, where he is a lecturer on criminal law. Professor Robert Whitman will look at how contract law and trust law clash both prior to the creation of a trust and at its termination. He received his JD from Columbia Law School in 1959 and has been a professor at UConn Law School since 1966, where his major field of teaching is in trusts and estates. However, I understand in his distant past he did teach contracts as well. Rounding out our panel will be Professor Deborah Zalesne, who will discuss cohabitation and co-parenting agreements in the context of family law and why these agreements should be more universally enforceable due to the underlying theories of contract law and the right to privacy. She earned her JD from the University of Denver College of Law and an LLM from Temple in legal education. She teaches in the areas of contracts, corporations, and commercial law at CUNY School of Law. I want everyone to know that we are running our panelists in order, and then we'll take questions at the end. So without further ado, Professor Fox.
Great. Thank you very much, Trey. And obviously, as everyone else has been saying, thank you to Jennifer in particular, and to St. Thomas and everyone at St. Thomas who's put this together. It's an incredible effort, but when it comes together like this, it's so valuable for all of us, and so we're very grateful for the chance to be here. And I'm also grateful to be on this panel. Other than me, it's a wonderful panel, and I'm thrilled to be able to have an opportunity to listen to everyone. So I'm going to be talking about, well, first of all, I want to say that this is when I first submitted it, I said, Jennifer, it's just a work in progress. And in fact, we have something at Stetson where we do periodically a half-baked thing. We call it half-baked. And the idea is it really is an early work in progress that you want to get feedback on. You have no idea where it's going. And I mean, I have a little bit of an idea where it's going now, but certainly when I submitted it, I didn't. So it's a work in progress. If it goes well, it will hopefully be something that's delicious to consume, like half-baked. But there's another meaning to half-baked, that you might decide that the presenter is actually himself in a situation where he should not be presenting. And it could be either one. I don't really know. What I do know is that what I'm doing is looking at constitutional interpretation and contract, but in particular, the connection between the long-term contract ideas and the Constitution. A little ahead of myself. The connection between contract and the Constitution has been explored most recently by some of the scholars of originalism, Larry Solomon, Keith Whittington, and Randy Barnett in particular. And they have done some very interesting things with looking at ideas of interpretation and construction and how that might play out in constitutional interpretation. Other people have criticized doing that, saying that Constitution and contract really aren't like each other at all. What I'm doing is looking at the possible connection between the long-term contract and the relational contract ideas and the Constitution. To do this, I will proceed in three parts. First, I'm going to look at the problem of analogizing across the gap, the doctrinal and conceptual space between contract and the Constitution. Next, I will suggest three areas where the analogy could be useful, and that's course of performance, modification, and reformation. Finally, I will look at some ways in which I think my analogy is an improvement upon what the originalist scholars have been doing. The first thing I want to say, though, is to make it clear that I am not saying that the Constitution is a contract, and I don't claim otherwise. I'm not getting into ideas of compact theory or social contract theory. All I really mean to address here is the possibility of analogizing, that is, taking some concepts from the long-term contract area and see how they might apply to constitutional law. Indeed, I think my goal is even more pedestrian than that, because I take no position on the normative question of whether contract analogies should be used, and that is, whether they're superior to other ways of doing constitutional interpretation. All I'm really doing is saying that if we do the analogy to contract, we should be doing it in the long-term contract situation and not from discrete contracts or classical contract interpretation. One of the reasons that I do not claim a normative privilege for the analogy is that I think the analogy has some obvious flaws. Contracts are traditionally between two parties, written by them, and the rules govern those parties only. The Constitution is multi-party. It's written by many authors, ratified by many other people, and then implemented by yet other people, and the rules govern everyone, not just those people who are involved in the writing. A contract is for a set of at least contemplated performances. The future it projects is normally time or event bound. The Constitution, on the other hand, knows not what it produces. It basically establishes rules whereby other rules are made. The Constitution projects into an indefinite and indeed a perpetual future. That is, it imagines that there is no end. Furthermore, a contract is all about consent and promise, right? It's the stuff of mutual intent between the identified parties. The Constitution, on the other hand, is constructive and collective consent, an ethereal and socially imagined union evident as much by the lack of citizen rebellion as by any indicia of affirmative assent. This is a problem that Randy Barnett has pointed out. Moreover, projecting forward across generations, as does the Constitution, any concept of consent drifts so far from the contract idea of consent that they really are in very different universes. But that's, I think, the rub. For once we see the separation between contract and the Constitution that I've just described, I think we begin to see the value of the analogy that I want to make. Especially for those of us schooled in the shadow of McNeill and Macaulay, for those of us about whom it's been claimed we are all relationalists now, we know that contract is not what it seems in this traditional view. Indeed, contracts often involve multiple parties. And here I don't just mean that you can have more than two parties entering the contract, but that most contracts are in fact entered into by corporate parties, that is, by entities that are already multi-party. They're collections of numerous people speaking in a collective voice. Moreover, such contracts often speak across time to non-consenting members. For instance, if you have a contract between Boeing and Delta, the workers building the plane in year 5, you have the contract entered in year 1. The workers in year 5 are bound to the framework of that contract between Boeing and Delta, even though they had no part in that contract. Of course, we imagine in contract land that these are separate contracts, right? That you have the Boeing contract with Delta and you have a separate contract between Boeing and its workers. Yet this is really, I think, only an analytic convenience, not a descriptive truth. And when the contract between Boeing and Delta is interpreted in year 5, it's the network of people across this multipolar structure that the performance is evaluated. Moreover, in year 10, when Delta is entering contracts to the air carriage contracts with people who buy tickets, you then have the extension of the relationship of the contracts, of all of those contracts, into the future and across different people. I think that once we sort of open this relational Pandora's box, we have paths across the contract and constitutional divide. The long-term contract, I think, contains concepts that are rich for constitutional interpretation and have largely been overlooked by originalists. What I'm going to do now is talk about three areas: the course of performance, modification, and reformation, and see how some of those connect to constitutional interpretation. All of the people here will already know that course of performance in contract involves the actions and inactions of the parties ex post. And here by ex post, I mean after the time of contracting. Under the UCC, course of performance is relevant not only to interpretation of the express terms or to fill in the contractual gaps and supplement the agreement, but in certain cases to rewrite the express terms themselves. The basic principle is that the way the parties actually act under the contract tells us almost as much about the meaning of the contract as do the words used at the time of contracting. This principle is especially important in long-term contracts because there you have the problem of the projection of the words over time and dealing with the uncertainty and changing events over that time. The question, of course, is how this works for constitutional interpretation. On the one hand, the justification for course of performance is that the parties themselves know best what their words of agreement and their actions of the agreement as an indication of their meaning, as you're looking to see what the parties understood. And with Constitution, the parties are constantly shifting. We don't talk about the parties in quite the same way. This, I think, is actually one of the things originalists have run into as they've moved from framers' intent to ratifiers' intent to original public meanings to the reasonable person at the time, right? It was just sort of the way originalists have been going, is they have trouble talking about the parties to the Constitution. But I think this is also true of long-term contracts. Right, such contracts are entered into, as I said, between corporate entities, and they extend over time, and the people are constantly shifting. The people who write the contracts are not the people who negotiate the contracts, and those people aren't the people who perform the contracts. And so this idea that we can really talk about a particular party even in a contract context, I think, is not quite accurate. Ultimately, I think what you have in talking about party meaning in the long-term contract is a much more elastic concept. As that it's an idea that in long-term contract, you're trying to negotiate between the idea of fixation, as fixing the terms under the express terms of the written contract, and elasticity, adapting the meaning of the contract over time. This is true to a much greater extent in constitutional interpretation. As the parties covered by the Constitution, that is, the constitutional actors as well as the people who are governed by the Constitution, as those people change and engage in repeated activities over time, they establish patterns of constitutional behavior. Such patterns, or traditions, to use the language of constitutional interpretation, are in a sense a course of constitutional performance. Perhaps the clearest example of this is actually from Justice Frankfurter's concurrence in the Youngstown Steel case. This was a case involving the separation of power and executive power. And notice that he's using language that is very much like what we do in course of performance. Systematic, unbroken executive practice, long pursuit to the knowledge of Congress, never before questioned. That can create constitutional meaning and constitutional powers for the executive. Note here that particularly the emphasis on openness and consistency, both of which are contained in the course of performance. Here I pulled what is the current UCC 1303 for course of performance, but repeated occasion, knowledge of the nature of performance, and opportunity to object. The same principles you see, I think, in constitutional interpretation as you do in course of performance. The course of performance analysis, I think, is more complicated where the issue involves the limitation of government power. In this example, in the Steele case, it was separation of powers and the establishment of the relationship of powers. But when you're talking about the limitation of government power and the protection of individual rights, the question is much more difficult. That is, we can't really use the government practice in the same way as we would in other areas of constitutional law. But here I think it is helpful to think of the parties to the Constitution as not just the constitutional actors, the legislature or the executive, but the people themselves and also the courts. So for instance, stare decisis could be seen as a type of performance over time sufficient to indicate interpretive change, as could the changing practices of the public more generally. I think the First Amendment is a good example of this. We didn't really have First Amendment law prior to 1900. It was the actions of individuals, both in the press and individual speakers, and the response to those actions by the courts that changed constitutional law. So our First Amendment law is very much, I think, a course of performance of the meaning of the Constitution. I think that this is even more problematic, however, when you get to areas of the Constitution that involve aspirational ideals. And so this is especially true in equal protection law, for instance. If we were to rely on course of performance and equal protection, we would have to embrace, not reject, Jim Crow and Jane Crow. As we would be in a situation where, rather than equal protection, we would have something that constitutional law that's neither equal nor protective. And so I think that in the aspirational context, the terms of the Constitution that are themselves aspirational, this analogy probably breaks down. And that's one of the things that I'm continuing to explore. In the area of modification, contract law presents an intriguing problem, of course. For those of us who teach contract, this is sort of the problem. The parties fix a meaning in a contract, but they also have the ability to change that meaning afterwards. And one of the problems, of course, is when you have a written document, and then even if that written document contains a no oral modification clause, the courts say the parties can basically still orally modify. And because when they modify the price terms or something else, it's implied that they are modifying the term of the contract that says you can't orally modify. So there's this privileging of the later in time choices that the parties make contractually. Now, this also under the UCC presents an interesting problem. So the UCC is used a lot of times as the model for some of the long-term contracting points of view. You'll see here the UCC approach to modification is more flexible than the common law in that it does not require consideration, but it is more restrictive, and one of the few places where Article 2 is more formalist than the common law, because it basically recognizes the importance and status of the no oral modification clause in a way that the common law generally does not. This, I think, is an interesting point, because one of the things that I'm looking at is the possibility that the amendment clause, all right, so this is Article 5 of the Constitution, can essentially be seen as a no oral modification clause. And the question then is whether under the Constitution, this is the key problem for originalists, is whether you can essentially have modifications outside of the amendment process, right? So that if you have an interpretation that changes the Constitution, that would be seen by originalists as an amendment and invalid. This is one of their sort of stronger claims. But I think that the UCC model presents us with a possible way of dealing with this. And that's because under the UCC, you cannot do the modification or amendment outside of the context, right? Once you've established it can only be done in one way, it should be done that way. But under the UCC, this only happens with the context of a very flexible course of performance and waiver approach. So you can have a restriction on the changing of contract in this way as long as you are very open to course of performance and waiver as a way of dealing with the fixation of the terms over time. And so I think that it would be a way out, and if we think of constitutional interpretation as supplementing this type of sort of strong amendment restriction but open interpretive area, that model and analogy actually works. I'm going to make a quick couple final points. I'm going to show you the type of thing that I'm looking at with Reformation, and then maybe make one quick concluding point. Reformation in the long-term contract context is seen as a much more important remedial tool than it is in other contexts, because it's a way of keeping the relationship together, giving the court the power to make some adjustments that make sense given the context of the parties' relationship. In some ways, this is what the court has already done with the Constitution. For instance, the Constitution says that every state is guaranteed a Republican form of government. This basically has no meaning in constitutional law anymore. This is essentially deemed as unenforceable as a political question doctrine. Similarly, under the 14th Amendment, the Privileges or Immunities Clause has basically been erased. There is almost no law involving privileges and immunities. The Supreme Court has essentially taken this out in a lot of ways. Similarly, with the Second Amendment, most recently, I think the Supreme Court in Heller probably just basically used the blue pencil on the first clause. And the court goes the other way. So on Amendment 5, there is no equal protection clause, but the court has added one on. So what you see the court doing over time, I'm making no claim about whether any of these are right or wrong right now. What I'm doing is just identifying that this is a practice the court engages in. It uses the contractual blue pencil to change the document because it's responding to practices over time. And you can argue about how it should better do that, but the fact is that it does that. And I think that if we take the long-term contract point of view, rather than thinking of the Constitution as a discrete document with a fixated meaning at time A, right, we think of it instead as a process of continual re-agreement, which I see in the long-term contract context. I think we get a more sophisticated and interesting relationship between contract interpretation and constitutional interpretation. Thank you.
Okay, hi everyone. Like everyone else, I want to really thank the folks at St. Thomas, and I'm so impressed to see so many students here, especially on a Saturday, and very impressed as well to see so many of Jennifer Martin's colleagues here. It really reflects well on the law school, so thanks for your hospitality here. So as Trey said, I'm the bankruptcy part of the program, and my paper, like Professor Fox's paper, is an early work in progress. I actually was really delighted about the timing of this conference and also the openness of the organizers to let anybody speak who has anything to say vaguely related to contract, because I need to present this at another event in April and then have the paper done in June, and I thought, well, gosh, this will be great to be able to present this to some contracts folks, because you know, in bankruptcy, there's so much that involves both contract and property, and you know, you hear that bankruptcy exists basically to blow up contracts, but bankruptcy law also respects property rights and respects the property rights that are created by state law. But where's the line between them? And what I'm looking at particularly is the line between property and contract in security interests. Okay, security interests, both under Article 9 of the Uniform Commercial Code and real estate security interests, so mortgages. And the impetus for this paper, so the other conference that I need to present it at is an American Bankruptcy Institute conference that is in furtherance of the ABI's work with its commission to study the reform of Chapter 11 of the Bankruptcy Code. And so Chapter 11 was adopted back in 1978 with the rest of the Bankruptcy Code. And so that's now, you know, more than 35 years ago. And since then, there has really been an explosion in the use of secured credit. Back in 1978, lots of companies that sought protection under the Bankruptcy Code had a capital structure that included, you know, some secured credit, but some unsecured credit as well. And so companies that filed for bankruptcy had some property that was unencumbered by security interests that could be used to fund used as collateral to fund their reorganization. But since then, because there's such an huge use of secured credit and companies enter bankruptcy with all of their assets encumbered by security interests, there is a fear that Chapter 11 has lost its balance and a fear that secured creditors have excessive control over the Chapter 11 proceedings. So therefore, the goal of the ABI Commission is to propose reforms to Chapter 11 that will, in their words, better balance the goals of effectuating the effective reorganization of business debtors with the attendant preservation and expansion of jobs and the maximization and realization of asset values for all creditors. So then the question is, what are some of the examples of excessive control powers that secured creditors have? And I'm just throwing these out as examples because the purpose of my paper is not really to analyze whether these are excessive control powers, but more to analyze what it means to be a secured creditor and what the actual property interest is and what the contractual rights are. So, but some of the examples are as follows. So, as I mentioned before, now companies go into Chapter 11 with all of their assets being encumbered, and so today's restructurings are not the traditional restructurings of 35 years ago. 35 years ago, a company would seek protection under bankruptcy law, it would sell unprofitable parts of its business, and propose a plan of reorganization based on the streamlined business. Today, the more typical Chapter 11, I mean, you still see some of the old-style Chapter 11s, but much more often, plans tend to be quick sales or liquidations under Chapter 11. So there will be a going concern sale of the company, and that is really orchestrated by the secured creditor with with an interest in all of the company's assets, which raises a question. I mean, bankruptcy is supposed to be a collective proceeding, right? Creditors have rights under state law to foreclose, gobble up all the assets of their debtor. So why should these creditors be using bankruptcy law if there's only one major secured creditor who's going to get the benefit of the bankruptcy proceeding? Related to that, and something I mentioned a moment ago, it is impossible to fund a reorganization plan when there are no unencumbered assets, and what that leads to is a secured creditor being likely to push a so-called fire sale in bankruptcy, and particularly when that creditor may be oversecured, so in other words, more collateral there than the outstanding loan amount, and a fire sale in bankruptcy is not beneficial to all the creditors, right? So again, why not use your state law rights? So the Commission is talking about several possible reforms to Chapter 11, and just to illustrate what they are without going into the merits of them, for instance, one reform that is on the table is the elimination of a secured creditor's right to credit bid. Okay, so under state law and under bankruptcy law, if a secured creditor has a $200,000 lien on a building and is foreclosing, that secured creditor can bid $200,000 for the building in the sale without having to put out any cash, right? So that's the credit bid, and the example I give is a very simple one. In a expensive reorganization, there are some problems with that. Another provision of the bankruptcy code that is on the table, or part of the bankruptcy code that is on the table, is the absolute priority rule, which requires that senior secured creditors get paid in full before anybody else gets anything. And one justification for that rule is that it mirrors what happens outside of bankruptcy, right? That would happen under state law as well. You know that from corporations. Shareholders can't get paid until creditors get paid in full. But then the question becomes, really, what are the substantive rights of a secured creditor outside of bankruptcy, right? So if the reorganization process, which today is often a going concern sale of a company, if that process results in some extra value that would not come about under the state law proceeding, who gets that extra value? Should it be the secured creditor or should it be the other creditors? So in this paper, I'm not setting out to evaluate the possible reforms to Chapter 11. In fact, there are a lot of people who know a whole heck of a lot more about Chapter 11 than I do. Instead, I'm intrigued by the testimony of so many of the experts who have testified before the Chapter 11 Commission, who have said that the right, sort of very broadly, that rights of secured creditors are almost inviolable in bankruptcy. And they get that from a 1979 U.S. Supreme Court case called Butner versus United States. And when I over lunch, Neil Cohen asked me, well, what's the 2-minute version of your talk? And I sort of mumbled for more than 2 minutes, and he said something along the lines of, oh, well, what you're saying is courts do whatever they want on this issue, and then they just cite Butner for their backup. And that's pretty much it. And it's really pretty interesting, because it's a lot of Supreme Court cases that repeat this over and over again. So the statement from Butner is one that others have observed probably didn't need the Supreme Court to even say. It has morphed into this rule that has gotten just larger and larger and larger than it was meant to be. But the rule that is often cited by courts, by scholars, I've done it too, by commentators, by practicing lawyers, is that property interests are created and defined by state law. Unless some federal interest requires a different result, there is no reason why such interest should be analyzed differently, simply because an interested party is involved in a bankruptcy proceeding. Okay? So what I'm doing in what will turn out really to be an essay is writing about what I call the use and misuse of this case by the courts. And so I make a couple of preliminary conclusions. One is that Butner really defines the package of rights that parties have in property at the moment of a bankruptcy filing. Okay? And the Bankruptcy Code can and does modify that package of rights as part of the bankruptcy process. Therefore, if a compelling enough federal interest exists, one fix would be to amend the code, although, what we were really playing with is what we could cleanly define as property that might raise a takings issue for existing secured creditors. Now, that said, some read the case to mean that a property interest can't be modified even in bankruptcy. And, generally, the secured creditor gets the value defined in monetary terms of its claim in bankruptcy. And you really don't want to mess with that too much, right? But then the question is, what is the value? Is that simply the dollar amount that the secured creditor would receive on foreclosure? Or, as I said before, should we recognize that if the business is being sold as a going concern, that there's probably some value that should go to unsecured creditors? Now, the more troubling group of cases, though, is that some read the Butner case to mean that a secured creditor should retain all of its remedies in bankruptcy. And then the question is, are all of these remedies really protected property rights? And the Bankruptcy Code does modify remedies. Okay? For instance, once a debtor files for bankruptcy, the creditor cannot just foreclose. There's an automatic stay that goes into place. The creditor keeps its right to foreclose eventually, but just cannot do it immediately. However, some cases, and although I'm talking about corporate, or the sort of background for the paper is corporate Chapter 11s, some cases, particularly ones analyzing the 2005 consumer amendments to the Bankruptcy Code, imply that the remedies that are not already modified by the Bankruptcy Code are property rights that can't be modified by bankruptcy courts. And so when we're talking about remedies, one question is, are they contract-based remedies or property-based remedies? Another is, if they're rights that are just operable between the two parties, well, then maybe they should be viewed as contract rights, or are they rights integral to preserving the right holder's position vis-a-vis the entire world, in which case they should be viewed as property rights.
if rights are not part of the holder's so-called property interest, even if Butner should be read as broadly as it has been, there's no protection for them in bankruptcy. So therefore, a court should be able to impair those non-property rights that are part of a security interest, even in the absence of legislative action. Butner actually is a Bankruptcy Act case. So even it was decided shortly, it was a case that arose under the old Bankruptcy Act, decided shortly after the Bankruptcy Code was adopted. And its specific result was actually superseded by the 1994 amendments to the Bankruptcy Code. And what the case was all about was a mortgage creditor who was claiming an interest in post-petition rents from the mortgaged property. And the problem was the mortgage did not grant the mortgagee, the lender, a security interest in the rents. And under the governing North Carolina law, a mortgagee in that position could obtain an interest in the rents only if it took possession of the property. And the bankruptcy filing prevented the mortgagee from doing that. So at that time, there was a split in the circuits regarding the entitlement to rents. Okay, so pretty narrow question here, but the court took it to resolve this circuit split because what the minority of the courts had said, the minority of the circuit courts, had adopted a federal rule of equity granting the mortgagee a security interest in rents even if state law would not recognize any such interest until after foreclosure. And the majority of the courts, of the circuit courts, said that the question should be resolved in by state law, and the Supreme Court followed the majority. Now, why would we support why would the court support uniform treatment of property interests by state and federal courts? Well, the court gave three reasons. One, to reduce uncertainty. Second, to discourage forum shopping. And third, to prevent a party from receiving a windfall merely by reason of the happenstance of bankruptcy. Okay? So here are several examples of how this principle has really expanded and exploded, both by the Supreme Court and others. Some courts will paraphrase the Butner case to say that state law governs a creditor's entitlements in bankruptcy. Whether those entitlements are necessarily what we would think of as property entitlements or not. And so that extends the holding to contract rights as well as property rights. And one example was the Raleigh versus Illinois Department of Revenue case decided by the Supreme Court in 2000, which involved the burden of proof on a tax claim, which was an unsecured claim, so the Department of Revenue did not have an interest in any specific property of the debtor. And the court said, well, the bankruptcy filing doesn't change the rule regarding burden of proof on a tax claim if we'll look to the state law. We'll look to the state law because the burden of proof is a substantive element of the claim. So the reliance on the Butner case was, well, creditors' entitlements in bankruptcy arise in the first interest from the underlying substantive law creating the obligation. Now, there's not much harm here in the misuse of the case because the code itself provides that the extent of the claim at the bankruptcy entry point, at the date of the bankruptcy filing, is a matter of non-bankruptcy law. So what this case really dealt with was defining the pre-bankruptcy entitlement, not what happens to that entitlement during the bankruptcy process. So it's an overly broad reading, but sort of no harm, no foul. It gets a little bit more dicey with the 1993 case of Nobleman versus American Savings Bank, which is the Supreme Court case that decided that a Chapter 13 bankruptcy cannot modify a home mortgage in any way, meaning that even if the creditor is undersecured, it has to be paid in full. Again, the court stated, relied on the Butner case, stated that Congress had left the determination of property rights and assets to state law, and stressed that the property right does not mean ownership rights, but also security interests. Now, that actually should be pretty obvious to even a second-year law student who has had the good fortune of taking secured transactions. A security interest is a property right. But then the court went on to list the rights that a secured creditor possesses. For instance, the right to repayment of the principal in monthly installments over a fixed term, the right to a specified interest rate, the right to retain the lien until the debt is paid off, the right to accelerate the loan upon default, the right to foreclose, and the right to pursue a deficiency. Now, retaining a lien in the property, thank you, yes, is definitely what we would consider a property right, but right to repayment in monthly installments over a fixed term, that's going to vary. Right to specified interest rate, that's defined by contract. And in that case, the reliance on the Butner case was not only, well, actually, was in the first instance unnecessary, okay? Because the bankruptcy code itself stated that the rights of a secured creditor could not be impaired, okay? Or the rights of the holder of a secured claim could not be impaired. So basically, federal interest did require otherwise. Congress had included a special provision in the code regarding the required payment on account of home mortgages in Chapter 13, and the code provision forbade the modification of rights, not the modification of property rights. So the reliance on Butner was not only unnecessary, but also misleading, because the home mortgage debt has to be paid in full because the code says so, not because the right to full payment of a debt is a right that the bankruptcy code protects. So this is sort of where I'm going with this paper. I have lots of other examples and had no idea I would actually take up even 18 minutes talking about them. So my conclusions, really two paths of analysis here, and the two paths of analysis I'm going to take in my paper is one, what are the federal interests that require different treatment of property interests, but this is the contracts crowd, so the other line of analysis is even in the absence of a compelling federal interest, Butner should not be read to prohibit all modifications of a secured creditor's rights, because some of them are grounded in contract, not in property, and bankruptcy pretty much exists to modify contracts in an oversimplified way. So, thank you.
Thank you, Trey, and thank you all for coming in. The topic is the connection between criminal law and contract law. This topic has been occupying me for several years, and I began to think about the topic as a result of the situation I encountered in Israel. But don't worry, it's also relevant to the United States. A woman who had cancer needed a bone marrow transfusion. In order for the transfusion to succeed, it was necessary to locate a matching donor and to compromise the immune system of the cancer patient. A matching donor was found, and the donor signed a contract. That he obligates to donate the bone marrow. However, after the woman's immune system had been compromised, the donor refused to proceed, and all attempts to persuade him failed, and ultimately the woman died. Under contract law, such a contract is not enforceable, since this is certainly a contract for personal services. As what is more personal than taking someone's bone marrow, inserting a needle into the donor in order to transfer part of his body to another. However, over the above the contractual question, a question looms in the criminal sphere. If it is indeed impossible to force the donor to donate, can he be convicted of homicide? Assuming of course, proximate cause between breach of the contract and the victim's death can be proved. Contract law and criminal jurisprudence seems to operate independently. As contract law is the backbone of the civil jurisprudence, while criminal jurisprudence is one of the foundation stones of public law. However, to my opinion, some of the issues that arise under contract law are deeply connected to the question of criminal responsibility. In the case of failure to act in omission, criminal jurisprudence makes a sharp distinction between conviction for an act and conviction for an omission. When seeking to convict for an act, any act that resulted in harm will suffice to convict, while with regard to conviction for manumission, a defendant can only be convicted if a duty to act is identified. Sources of this duty to act are varied. Such duty to act may flow from a relationship between the defendant and the victim, such as a parent and child. Like a mother who fails to feed a young child will be convicted of manslaughter if the child dies of starvation. A similar duty may exist in the employer-employee context, such that if an employer fails to warn his employee of a danger, he may be convicted of manslaughter. According to most opinions, a duty to act may also arise from a contract between two parties. That is, in some situations, a person who breaches a contractual duty to act, such that the breach results in the death of another, may be able to be convicted of homicide. U.S. case law has treated a child care contract as an example of this principle. In People versus Wong, a couple undertook to care for a 3-month-old child. 3 weeks later, the baby was dead. The police investigation concluded that the baby had died as a result of shaken baby syndrome. The Wongs claimed that they had not shaken the baby. Rather, their son had done so. The court held that even if that was the case, the Wongs could be convicted of manslaughter since they had a duty to care for the child and had breached that duty. This is only one example, but there are a lot of examples for convicting because breaching the contract. Although what I have said, the issue of a contract at the basis of criminal responsibility is not a simple one. The first question is whether a contract that is not enforceable, such that a contract for personal services, can also serve as a source of such a duty in criminal context. At first glance, it would seem logical to conclude that if the courts will not enforce such a contract, then there is not real duty that can serve as the basis of criminal conviction. On the flip side, the second question is whether every enforceable contract can serve as the basis for a duty to act in criminal law context. What would we say with regard to a third-party contract between A and B that obligates B to protect C, where C is not even aware that such a contract exists? Let's see 4 scenarios for examples. The first scenario is drowning 1. Let's call it drowning 1. A is a good swimmer, undertakes personally to save B from drowning. B enters the water and encounters difficulty. But A does not save him. B drowns. This scenario is virtually identical with the case I mentioned earlier in which A undertook to donate bone marrow to B. B had an immune system compromised. A refused to donate and B died. And the second scenario is drowning 2. A is a good swimmer, undertakes personally to save B from drowning. Before B enters the water, A tells him that he intends to breach this contract and will not save him. B enters the water and encounters difficulty, and A does not save him and B drowns. The third example is drowning 3. B owns a beach and has a legal obligation to appoint a lifeguard for this. He contracts with A good swimmer, to act as lifeguard and to save anyone who encounters difficulty. C, who is not aware of the contract between A and B, enters the water and encounters difficulty. A does not save C and C drowns. In drowning 4, the fourth scenario, B owns a beach. He has no obligation under the law to provide lifeguard. Nonetheless, he hires A good swimmer, to act as a lifeguard and to save anyone who encounters difficulty. C, who is not aware of the contract between A and B, enters the water and encounters difficulty. A does not save C, and C dies. The first 2 scenarios involve valid contracts, but they are contracts for specific performance of personal services. As such, under contract law, it is not possible to enforce the contract by forcing the party to perform the service. Rather, the breaching party is required to provide monetary compensation to the injured party. The reason for this is protection of individual rights. Contract law is not interested in forcing a personal relationship upon someone, as this could significantly infringe upon his liberty. Therefore, just like contract law cannot force an author to continue to write a book, a lawyer to continue to work in a law firm, it cannot obligate someone to save his friend when he does not wish to do so. This analysis appears to lead to the following conclusion. Contracts that are unenforceable under contract law cannot serve as a source of a duty to act in criminal law, since there is no actual duty to act, but rather a duty to compensate. In order to evaluate this claim, we must examine the connection between the relief in cases of breach of contract and the contractual right in and of itself. Specifically, what is the legal significance of not enforcing a contract in cases of contracts for personal services? There are two main possibilities here. The first possibility, the legislator's decision not to provide the relief of enforcement for contracts for personal services means that contracts of this type can be fulfilled in one of two ways: provision of the services or payment of compensation that will put the injury party in the position he would have been in had the service provided. Thus, payment of compensation constitutes fulfillment of the contract rather than relief for breach. This approach assumes that relief establishes the very essence of the contractual right. As such, the relief is a full substitute for the right itself. The relief is the right. The position that with regard to contracts for personal services, there is no duty to act, but merely a duty to monetary payment unless the services is provided, is implied by Barnett, who maintains that it is not possible to transfer the right to personal service, but only the right to payment. I think that Barnett is of the opinion that there is a Kantian distinction between contractual duty regarding things external to one's body, such as a table or land, and things tied to a personal body. With regard to the second type of duty, there is an ethical barrier to undertaking to supply such services. Thus, A's undertaking to save B must be understood as undertaking to compensate B if he fails to save him. The other possibility is that a contract for personal services does impose a legal duty to fulfill the contract by providing such service, and the other party has the right to provision of that service. However, that party does not have the legal power to demand enforcement of the contract. Thus, payment of compensation is a relief rather than an intrinsic part of the original contract. In the contract law context, it makes no difference which of these two perspectives is adopted, since in any case, contracts for personal services will not be enforced, and the relevant relief is compensation. However, in the criminal context, there can be a very interesting and important implication. Under the first option, when someone dies as a result of failure to perform under a contract for personal services, it is not possible to view the contract as a source of a duty to act. Such contract cannot impose such a duty, since they can actually be fulfilled by payment of compensation. However, under the second option, such contracts may serve as a source of a duty to act, since although the injured party has no power to compel performance under contract law, there is a legal duty to perform that is a duty to act. Thus, while a court will not enforce the contract, the primary duty to act arising from the contract itself serves as a source of the duty to act in the criminal context. The reason for the dissonance between contract law and criminal law in this regard comes from the underlying rationales respective to each of these two spheres. In contract law, the force of the contract stems from the assurance provided by the one who obligates himself to perform. The legislators has determined that when human liberty is infringed upon in a significant manner, we will not force a party to fulfill the contract. In a contest between the value of keeping a contractual assurance of human liberty, human liberty wins. However, the rationale underpinning criminal law is the prevention of harm to others. Thus, despite the fact that the contract cannot be enforced under contract law due to liberty consideration, where harms has occurred, it is possible to use the contract as a source of a duty to act for purposes of securing a criminal conviction. Okay, what about rounding 3 and rounding 4? Since the third party is not aware of the contract, the entire issue of reliance is not relevant. In order to form an opinion, let us first take a look at the two principal rationales for the distinction between act and omission in criminal jurisprudence, the liberty rationale and the causation rationale. Under the liberty rationale, the prohibition against an act that causes harm does not significantly infringe our liberty, since all that is required is to refrain from a particular act. On the other hand, prohibiting omissions that cause harm does infringe significantly upon liberty, since such prohibition creates a situation in which at any given moment a person must interrupt his pursuits in order to prevent harm to others. Since legal system must permit people to conduct their normal lives, criminal jurisprudence has determined that people can be convicted for an omission only if a duty to act can be identified. Under this analysis, anything that imposes a duty to act can serve as a basis to convict of result crimes in general and homicide in particular. The reason is that, okay, if we apply this liberty rationale to our scenarios, we can conclude, at least on the surface, that it would be possible to convict A of homicide in Drowning 3 and Drowning 4. The reason is that there is a duty incumbent upon A to fulfill the contract. Therefore, one can argue that the legislator has decided that in such situation, consideration of liberty ought to be set aside, and there is no bar to conviction of A for homicide due to omission. In contrast, some argue that the distinction between act and omission in criminal jurisprudence does not rest on liberty of action, but on the causal difference between act and omission. Under this approach, when A drowns B, A causes the death of B. The death of B, since there is a causal connection between A's act and the death of B. On the other hand, when A fails to prevent drowning, A's failure to act does not have causal connection to B's death. Thus, in contrast to the liberty rationale, which maintains that the need to identify a duty to act with regard to omission springs from the desire to limit the infringement of the liberty, the causation rationale requires identification of such a duty to act in order to convict for a result crime in cases of omission to compensate for the weak causation between omission and the harm. That is the essential element of the crime. Thus, with regard to Drowning 4, it is doubtful whether it is possible to convict A of homicide. Under the causation rationale, only a significant duty stemming from the relationship between defendant and victim or defendant and the source of a danger can serve as a basis of homicide conviction. Here there is no direct connection between A and the victim, because the victim is not a party to the contract. Similarly, it is doubtful whether this contract creates a significant relationship between A and the source of the danger. The situation may differ with regard to Drowning 3, as there is a legal duty imposed upon the owners of the beach to appoint a lifeguard, and the appointment of A fulfills this duty. Whether the legislator has determined that someone is to be appointed to guard bathers, this duty creates a direct connection between that person and the source of the danger. Therefore, breach of the duty in this case may lead to conviction of A for B's death. My discussion here today leads to two different conclusions with regard to criminal conviction based on the contractual duty to act. The first possibility is that the contract in and of itself is the source of the duty to act, and the breach thereof is what can lead to criminal conviction. The second option, which I support, is that it is not the contract in and of itself that is the source of the requisite duty to act. Rather, the contract provides a platform for the creation of a personal reliance, social expectation, or spatial relationship, and these elements in turn serve as the source of the duty to act. Thank you very much for your attention.
Like my other panelists, I want to thank you for having me. Jennifer has been wonderful, and the editor-in-chief of the Law Review. And I have to tell you, where I come from, Connecticut, it's very cold. So it has been a real opportunity. When I first put the paper together, as it shows in the program, I was only dealing with the termination of a trust. But now it also deals with the moments prior to the creation of the trust. Once the trust or the estate is being administered, by and large, it's trust and estates law. But at the very beginning, before it starts, and at the very end, when it's finishing, contract law comes into play. And there is definitely a clash. And it would be nice if that clash were to be dealt with and such. But forces in the economy, namely corporate fiduciaries, would not like that to happen. And so you have to be careful, if you're in my position, to, on the one hand, make it clear that my interests are concerned with what I call powerless beneficiaries, and on the other hand, not go too far in squarely hitting corporate fiduciaries, because they're really very powerful, and in the long run, you need that balance, and the article tries to do that. When I took contracts in law school, I was not aware of the fact that I was being taught late 19th century contracts. And when I taught contracts, I was not aware that I was teaching late 19th century contracts. When I started to teach American legal history, lightning struck, and there was 18th century contracts, which is very different than late 19th century, and you'll see that as we go on. Contracts and trust law are divergent. There's a big difference. Some people would like to narrow the difference, but the fact is they're on two different roads. In 19th century contracts, for various reasons, they decided that the stronger party should have the advantage. That's when it was determined that the value of consideration would not be considered as long as there was a bargain for exchange, meaning the stronger party could have the benefit of the deal. But in trust law, they worked on fiduciary duty, and there wasn't that willingness to play to the stronger party. To the contrary, fiduciaries owe an obligation to their beneficiaries above the obligation to themselves. So we're talking about very different fields of law and how they interact on the populace. The paper starts with the origins and essence of contract law. It's very old law. It goes back in time to whoever was trading. If you were a trading nation, you needed to have contract law. It might have been rudimentary, but you needed to have it. So, not surprisingly, the Egyptians had it, Mesopotamia had it, the Israelites had it, the Hittites had it, Babylonians, Sumerians, all the ancients had contract law, rudimentary. When Rome came along, and you know Rome was a great law state, contract law was refined and brought up to a high level. A large percentage of what you would study in law school today has been dealt with by Roman law. And that was maintained until the breakup of the Roman Empire. That put us back into the Dark Ages, and the society went back into an agricultural society, and the law pulled back. But then, as time went on and the Renaissance came, contract law started to move up again. In England, and you probably all know that the English system, the early forms of action and so forth, were very rigid, and that's why equity developed. And the merchants were totally unhappy with contract law in terms of what they would get from the formal legal system. So they started their own courts, which met at fairs, international fairs. So they had a broad sweep, and they used their customs, and their people who they trusted would hear the case, decide the case, and the merchants were very happy. Eventually, the law courts realized that what they were doing was not helpful to people, and Lord Mansfield is credited with having left the court, gone to the fairs, listened to how they handled the disputes, came back to the court, and infused the formal contract law with the ideas that he learned from the merchants. And it's a very important idea. Carl Llewellyn, when he was the chief reporter for the Uniform Commercial Code, made sure that he had an advisory group of practicing lawyers so that he didn't come up with things that made no sense to them. Also, interestingly, he left law teaching after a couple of years to practice because he felt that he needed that practice experience in order to be able to put things together that made sense. Now that brought us to 18th century contract law, and the emphasis there is on fairness and social utility, not on playing to the powerful forces. So the seminal case was Seymour versus Delaney in 1822 in New York, where the parties had bargained for the exchange of city lots for country acreage. And the matter came before Chancellor Kent. He went through the history, including the Roman law and the early contract law. Oh, thank you. Okay, I gotta hurry. And he said, it's not fair. You gotta have a fair consideration. And he was then reversed by a higher court because they were into already late 19th century law. Now, the origin of trust law, very different, relatively new. Fellow would go off to the Crusades. He would think that he might not come back, so he would say to his friend, would you manage the land? And then he'd come back, and his friend wasn't such a good friend. He had misused his position, and originally the courts had no remedy until it was coming more and more, and so the equity courts decided to enforce the Crusaders' rights, and that led us to the trust. At the termination of the trust, the clash is that a corporate fiduciary says, unless you sign these receipts and releases, which are contracts, we're going to force you to account to the court, fiduciary accounting, expensive, costly, time-consuming. So they're actually forcing the beneficiaries to do what they want because they're going to use the contract. Very consistent with contract law, not consistent at all with trust law. Before the trust starts or the estate starts, they have a contract which they give to the settlor, and the contract is one-sided for them. But in fact, they know they're going to be fiduciaries. They know they have a higher obligation, but they cut it off, and they say, well, it's the contract. And at the end, they cut it off, and they say, it's the contract. Case law is now coming along, particularly at the end, challenging the whole setup and putting aside the receipts and releases to the point where they're not necessarily worth the paper they're written on. And I think what we're seeing at the end is a wave of change that will benefit the beneficiaries and stop the practice. Similarly, at the beginning, if you go through one of the initial contracts and it says a corporate fiduciary can raise its fees whenever it wants, that's not exactly what fiduciary law would think was right, but contract law would sanction it. And so that is the end of the story. It's a fascinating change that is coming. Cases are building up, and we're beginning to see courts change in their attitude. And thank you very much. Here, take the mic.
Okay. So, yeah, it's been an interesting panel because I first looked at the program and I thought, okay, they just put a bunch of the rest of us together that sort of didn't fit somewhere else. But actually, really, our papers fit together perfectly so far, and I'm the end, so I would say they seem to fit together really perfectly because we're dealing with the clash between contract law and other doctrines, and really everyone's sort of stuck to that theme, and mine will, I think, do that as well. Professor Whitman was talking about how contract and trust law are divergent, and Professor Rosenberg talking about how contract law and criminal law are, whether the definition of contract is the same or different under contract law versus criminal law. And I like the way, so Professor Rosenberg was making the distinction that the kind of definition of contract law is different in these two doctrines because the goals of contract law are different from the goals of criminal law. And that criminal law has the different goal of sort of preventing harm rather than achieving the benefit or protection of the private contract. In a sense, my article is really addressing the same thing, whether the definition of contract or the use of contract law is the same in the context of contract law versus the context of family law. First, I want to make the side note that it's an overstatement or understatement? Understatement to say that I'm not an expert in family law. I have no experience in family law. It's not my area at all. So this paper that I'm working on is my first dabble into family law. And as might be expected, my experience with working with family law and the comparisons, it turns out I'm really giving the contracts perspective on contracts that exist in the family law context. But in terms of comparing the two, I would say that in the typical situation, even though this area of law is really rapidly changing in the last, several years, I would say that when people do enter into contracts that are part of family relationships or trying to define their relationship or trying to secure rights in a relationship, still today, although like I said, it's changing a lot, most of the time these kinds of contracts are still not enforced or they're subject to greater scrutiny compared to contracts outside of the family context. And so here I'm talking about a wide range of types of contracts that exist in the family context, like cohabitation agreements, co-parenting agreements, surrogacy contracts, contracts to buy genetic material, gestational services, all kinds of contracts between spouses, partners, non-married partners, et cetera. And sort of continuing with this framework, I would say that a lot of times I think the differences are based truly in the different goals between contract law and family law. And if you think of the central idea of family law as protecting families and protecting marriage and protecting children, and you think of the central idea of contract law as protecting autonomy and the marketplace and whatnot, and you pit these two against each other, protecting the market versus protecting children, children are going to win, right? It's a hard argument to make that the autonomy of the parties and protecting the market should govern over protecting children. So really the framework of my paper is based on the idea that this clash between protecting the market and protecting children is sort of a false, it's a false distinction. The battle here between these two ideas they're falsely put against each other. And my article kind of proposes reframing the question in a way that makes it make more sense. And so not one about the market or autonomy versus protecting families, protecting children, but really protecting sort of traditional ideas of family versus protecting sort of a more modern view of family, which contract law, by its nature, allows for. Contract law allows for non-traditional families to create rights for themselves or define themselves in a way that are different from the traditional ideals and ideology from family law. So I mentioned all these various types of contracts in the family context, but my paper focuses on cohabitation agreements and co-parenting agreements as two of the more difficult examples. My talk today is just really going to focus on co-parenting agreements as I think the most, only because for time purposes, but I think as the most complex or difficult type of contract to address in the family context. So here I'm talking about agreements that are arranging visitation and custody among parties with respect to their children. And the co-parenting agreements that I discuss in my paper and that I'll discuss now are co-parenting agreements not among two biological parents, which they enter into agreements as well, post-divorce typically, but I'm talking about two co-parenting agreements between two parents, either in the case where neither of them is a biological parent, or in many cases where only one of them is the biological parent, and sort of how those compare to contracts where both parties are biologically related to their children. And my proposal is simple in terms of the theory. It works off the idea that when you're establishing relationships and families, that non-biological parents deserve the same rights that biological parents get, simply through their biology and simply through their natural physical relationship to their children. Historically, and I would say a little bit less so today, but continuing today as well, co-parenting agreements entered between two, so I'll call them intended parents, but not biological or not adoptive parents, were typically, and again, tend to still not be enforced because of the fact that they can circumvent the best interests of the child standard. So we're talking about a private contract where parties are making decisions about the care and custody of children, who should have custody of the children, who should care for the children, private contracts versus family law, which requires that custody be decided based on the best interests of the child. And of course, there are concerns, and rightly so, about making these determinations without considering the best interests of the child. And a lot of these agreements are made pre-conception. So how can you determine the best interests of the child before the child is even born? So, logically, a child's interest shouldn't be subordinated to the parent's right just to have to freedom of contract, enter into a contract. And a major critique of contracting in this area is simply that parties should not be able to contract around the state authority that demands consideration of the best interests of the child. So instead, lots of times these contracts, and again, this is state by state, and there's just so much variation, so it's kind of hard to summarize. But I would say that in most cases, or in many cases anyway, these contracts are not enforced as written, but instead they are considered one of other factors in determining what's in the best interests of the child. So the doctrine that's being applied is the best interest of the child standard, and the contract is simply one factor to consider, which of course is different from contract law that would enforce a contract if it was entered into freely among consenting adults, et cetera. So again, it's sort of at first glance, this seems correct that decisions need to be made in the best interest of the child. And I believe that it's correct, that decisions need to be made in the best interest of the child. But what my paper suggests is that this hurdle of the best interest of the child is, when I say hurdle, I mean hurdle in the preventing the enforcement of the contract. This hurdle is not equally applied to non-biological parents as compared to biological parents. So it's not applied equally among all intended parents. And so what I suggest is that enforcing these contracts does not have to be at odds with the best interest of the child standard. They don't have to conflict. And we can see how that works in the context of co-parenting agreements between biological parents. And it's hard for me to keep saying biological and adoptive parents, but we're talking about parents with a legal right through biology or through adoption. So forgive me if I if I don't say that correctly every time. But contracts, so biological parents have a constitutional right to the care and custody of their children. And the law presumes that it's in the best interest of the child to be raised by his or her natural biological parents. And this presumption is based on the idea that the natural bonds of affection would lead parents to behave in a way that's in the best interest of the child. When two parents have a child naturally, there's no requirement for court approval. Courts don't first say, yes, you can be a parent, you cannot be a parent, of course. And it's just assumed that parents, once they become parents, will behave in the best interest of their natural children. And that parents know better than courts and have more information and better information about their family functioning than third-party decision makers or courts or judges, and are better able to make workable plans for the care and custody of their children, especially in the case with biological parents who were married. Typically we're talking about post-divorce, making the decisions about the care and custody of their children after divorce. So in fact, contracts, co-parenting agreements entered into by biological parents are not only enforceable, but they're readily, very clearly enforceable, but they're encouraged. They're encouraged based on a variety of things, but public policy that favors prompt resolution of disputes, better for them to make their own decisions than use the court system, and based on this sort of a further idea that most families will benefit from parents making these decisions themselves. Families will benefit because, first of all, it's less contentious, there's no court involved, and just generally cooperation and involvement of both parents is believed to lead to greater overall better family situations, well-being of families. And so with contracts entered in between biological parents, like I said, they're generally enforced, they're encouraged, and courts will only step in if there's some allegation or sense that one of the parents is not fit. So the determination is still made based on the best interest of the child standard, but there's a presumption it's in the best interest of the child, and the contracts are enforced unless, again, like I said, unless one of the parents is unfit. With non-biological parents, so again, it may be one or both of the parents is not biologically related to the child or has adopted the child or children. Basically, to get custody of an intended child, they go through a more rigorous analysis of which custody arrangement would be in the child's best interest. So courts are still doing a best interest of the child analysis, but without the presumption that the intended but non-biological parents, without the presumption that they are acting in the best interest of the child. And in fact, non-biological parents don't even have standing to file a claim for custody. If they're not biological and non-adoptive, they don't have the standing absent contract. So contract is really an indispensable tool for non-biological intended parents because it's their only means to get into court to help to make these claims. So my paper advocates using contract as a means of giving non-biological intended parents the same status and presumptions that biological parents have, nothing more, nothing less. Not to say contracts should be enforced as opposed to the best interest of the child stand. You know, when it conflicts with the best interest of the child, and in the sense that a parent is unfit, it would be the same analysis as is done for biological parents. But just to give the same status and the same presumptions that biological parents have. Therefore, putting non-biological parents on similar footing to biological parents, we're not sidestepping the best interest of the child standard and seeing them as operating side by side. I think I already said all this. So basically, just a couple of arguments why the best interest of the child standard has room for, and it makes sense under the best interest of the child standard to give these same presumptions to non-biological parents. First of all, the best interest of the child standard is very often viewed as, well, certainly flexible, a lot of discretion with the court, also oftentimes viewed as very vague and inherently subjective. So this flexible nature of the best interest of the child standard makes space for this kind of presumption in favor of non-biological parents, the same as biological. And critics of the best interest of the child standard, which from my understanding there are many, talk about the vagueness, the indeterminate outcomes, how courts are not are not in the best position to determine best interest of the child. And the standard invites litigation, imposes a lot of costs and burdens on the parties, and so it makes sense that private contracts in this area could circumvent some of these problems that are inherent with the standard, best interest of the child standard. As I said, if family members make these determinations themselves, less hostility between the family members, the families themselves, more cooperation, greater determinacy, clarity, etc. The presumption also makes absolute sense at giving the presumption to non-biological parents, the same presumption that biological parents get, makes sense in light of changing attitudes towards non-traditional families, which I don't think we can even call non-traditional anymore because, it's like how minorities are now the majority. Well, this is sort of the non-traditional families are sort of becoming very standard. Non-traditional families meaning partners who are not married, partners who are married but have children through other means. Alternative reproductive technology gives so many different options for people infertile, where one member of the couple is infertile, or same-sex couples to have children through other means. And this is becoming, obviously very common. And so the development of the law, of course, should follow the development of our culture and society. Giving this presumption to non-biological parents also, of course, makes perfect sense in light of the natural bonds that are likely to form between non-biological parents and their children, their intended children, in the same way that bonds form between biological parents and their children. It seems very arbitrary to talk about the natural bonds between a biological parent and their biological child as being any different from parties that take the time and effort and money and space to create, to have a child through other means. Of course, you could almost say that those intended parents, it's almost like you can have naturally you can have a child by accident. You can't have a child by accident through the other means. So to think that the bonds that form between these parties are any different doesn't make a lot of sense, treating biology as the only determinant of, oh, that was my timer. But you said I didn't know that was going to make noise, sorry. I never did that before. I'm turning it off. I did 18? Okay, good. I'll just finish it up. I typed in 18. I also have like 7 texts that are happening right as I'm speaking. I don't usually bring my phone. Anyway, well, my only final note. So that's the gist of my paper. That trying to view the distinction between contract law and family law not as a clash, but as two areas that can coexist, and just bringing contracts between non-biological parents, giving them the same privileges, rights, and presumptions that biological parents have. Like one quick final note about co-parenting agreements and the market. A lot of the public policy arguments about not enforcing these contracts in the family law context have to do with the fact that it's inappropriate to apply contract law to family values. These contracts devalue life and they exploit people. They
commodify women, commodify babies, et cetera, all these kinds of arguments that the marketplace is not the appropriate place to be talking about, in particular, children and custody of children. If I had to summarize it in 5 seconds, which I think I do, just to say that in our society we already routinely determine parental rights through market avenues in the context of adoption, in the context of a variety of alternative reproductive technologies. There's been a lot written about this, but there's a functioning market already, and so just to bring the case law consistent with the market that already exists. I guess I'll stop there. Thank you.
And I'd like to open up to the floor if anyone has questions for our panelists. Professor Martin?
Well, I first want to say, I didn't design
I
this.
forgot to thank you.
Oh my God. But I absolutely did not design this panel by accident. I thought it was pretty amazing to see the intersection of contract law with so many other doctrines. I thought it was just amazing. But I was thinking in terms of both family law and trust law, because I'm sorry I missed some of your guys' other presentations, about the role of assent. Because I see sometimes where we, and assent is, of course, one of the hallmarks of contract law. And I was thinking, someone in the trust area, if you assent can only go so far because you have fiduciary obligations that are, I guess, parameters that we all have to respect. And I guess in the same thing in the family law that assent rules, but maybe there's some outlying parameters. But I was wondering if both of you guys would comment on assent, because I still think contractual assent still rules the day, that so long as we could agree, we could often make all kinds of crazy agreements for our children so long as we agree, putting aside maybe the surrogacy agreements where we know from baby M that eventually if someone has regret after the fact that perhaps they might be able to undo the agreement. But there seems to be wide latitude when there is assent, in fact. So
it's an excellent question. If you don't mind, I'd like to answer from the trust point of view. Unless there is absolute and full disclosure, assent does not carry the day. And that's what's going on, because the questions that now come up, how much do you have to say in a fiduciary accounting to alert the beneficiary that you goofed? Because if you don't say an adequate amount, later on, after the signing of the receipt and release, the beneficiary comes back and says it's not valid because you didn't tell me, because I only discovered in depositions, and that's what's happening and is being recognized. So there are actually some law firms that completely get away from receipt and release. They give out the money, they say nothing, hoping that the beneficiaries won't say, what's going on here? Why are they asking for this receipt and release? I'm going to get independent counsel. And if they don't get independent counsel and the statute of limitations runs, then they've accomplished for the corporate fiduciary what they've wanted. And it's beginning to appear that that's a better route than requiring the receipt and release, or we're going to pull you in for an expensive proceeding.
Well, in the family law context, I mean, I think one of the biggest hurdles for enforcing these contracts is proving that there was assent, because a lot of times these are implied contracts, and courts are looking for a very specific, explicit written contract, or at least explicit, but typically written contract. And that, I think, is one of the biggest hurdles. And I think one of the big critiques of these kinds of contracts in this context is that like there's a big feminist critique of, or feminist and other critique of these contracts because there's so often unequal bargaining power, so the assent might not be truly voluntary. And if you're talking about a woman just being faced with giving up her child and has to, I think this is, a really legitimate valid concern. My view on that is that, and it's so strange because when I teach contracts, I teach from a perspective of undoing contracts in those cases. That's my, unequal bargaining power is a problem that has to be addressed in dealing with people with weaker positioning and whatnot. But I think there's sort of human rights arguments on both sides in these cases. So you're dealing with those situations versus using contracts as a tool for empowerment and a way for parties to gain rights that they don't otherwise have through that if they're not married, they can't marry, they can't have children and whatnot. And since I see these important competing policies on both sides, overall I think the contract should be enforced, but with the same parameters that I believe all contracts should be enforced, considering bargaining power and with the umbrella of unconscionability and whatnot. So with defenses that should be applicable. But it's a tough question because two important values that odds with each other.
This is for Roni. I was intrigued with your analogy of whether your analysis of crimes that arise from a different source than the pure contract itself. In other words, that you just because something's a breach of contract doesn't make it criminal. It reminded me of the distinction that some courts are making in the U.S. on the economic loss doctrine between a duty that arises solely by contract and is also a tort that is also a tort. Washington has the view that if the tort arises from an independent source, then the tort could permit the recovery of these damages. But the point I wanted to make to you about the other relation about specific performance is when I teach remedies and I teach specific performance, one of the questions I usually give the students is, well, if a person has a contract duty to perform a contract, why should they object to being under an injunction to perform it? I mean, other than the fact that people may say, well, I have an option to pay damages or something. And one of the answers that students don't realize is that in America anyway, the intentional breach of an injunction is a crime. In other words, if you are under an injunction to perform a contract and you fail to perform it willfully, then you committed criminal contempt. And so the effect of a specific performance doctrine is to criminalize breach of contract. So it's kind of like a flip side to what you're talking about.
Okay, so in the United States, if you intend to breach the contract, is a criminal?
If you are enjoined to perform it, the court has entered an order to you personally to perform the contract.
Yeah.
And the sanctions for that can be civil, but they can also be criminal. And it's rarely used in civil cases, but it's technically criminal contempt is a crime. So basically, you criminalize non-performance of the contract, and that might be a reason for someone to resist an injunction.
Okay. So it's a question?
No, I'm just an observation. There's no question.
No. It's interesting.
Yes. It struck me just as an observation about how nicely this panel fit with, even though Professor West is in the other room, I think her talk is in some ways in this room, right? Some themes from her talk come up because contract as a way, right, with your paper, it's contract as a way to get access, right? This is contract as a way to enter civil society, but also some of the problems. So the duties, right? The duties that come with entering civil society, or the problems with having contract run up against other spheres, right? So the sort of underlying principles of the other spheres, and the underlying principles of contract. Roni, and so if you take Professor West's point of view, you get that, you have to work that conflict out in each case. It's a sort of very pluralist idea, and I thought that was really interesting how these sort of fit with that.
Do you have any more questions or comments from the panelists?
Question, actually, kind of relating to the family law issue. You touched on this somewhat with mentioning that the non-traditional family is becoming more traditional. To what extent do you think that the best interest of the child standard will just change with having, say, like younger judges interpreting that standard? And is it just that would be too slow of a transition to wait for that?
It might just be that it will transition. I mean, from my review of cases, it looks like things are changing a little bit, but still, so my paper also addresses cohabitation agreements, and in that area, there's so many statistics that people are not marrying anymore, but there's couples that are cohabiting and not the idea of a private contract, interfering with that is extremely outside of any notions of, I think, even what progressive thinking people would expect. So maybe it'll just take longer, or maybe it won't, I'm not sure, but again, I'm not saying that contract should win over the best interest of the child, but just to coexist. But so it's an interesting question. I don't totally know the answer right now.
Yeah.
I think the issue with the best interest of the child is because they take it case by case before the judge, and the judge reviews the whole case. Maybe if there was some way to balance a time sharing agreement with what is still in the best interest of the child, because sometimes, now they try to do an equal, from my understanding, they try to do an equal sharing between both parents. But if it's in the best interest of the child, because their school is over here doing it that way, maybe if there was a better balance between that, it might.
Right, but right, but my proposal is that see what happens is the non-biological parent sometimes has inferior rights to the biological parent. So despite what otherwise would be a balance, it's imbalanced. So I agree with you, it should be more balanced. Or, another way to look at it really is I just think the contract should be enforced without making whatever, it doesn't matter if the contract is balanced or not balanced. It might give visitation rights to one party twice a month, and the other party gets the rest of, custody the rest of the time. That's not balanced, but if that's what they've agreed,
Yes.
I feel like it should be enforced unless you can show that.
But that's what I mean, because a long time ago when I worked at a firm, in some cases where the parent lives closest to the school and the school is in, the best, then that parent got the child during the week, and the other parent, and that seemed to be in the best interest of the child, even though the other parent only saw the child twice a week. And I think if there was a better way to balance
apply
that,
the standard.
then it would,
Yeah.
it wouldn't matter if it was biological or non-biological, if they would even that out.
I have a comment and a question for Professor Rosenberg. The question is a sort of comparative law question, because at least as I understand the different legal systems take different approaches to a duty to act. French law, as I understand it, has a broader scope of what a duty to act entails, a background duty to act. So I wondered whether there were any corresponding differences in the criminal law, given the difference in a background duty. So the question, and then the comment having to do with what contract entails. Is it, as Holmes would have it, either you perform or you pay damages, or is it something else? And this, you see this there's a 50-year-long debate between Oliver Wendell Holmes and Frederick Pollock on the matter that is from their first letter to their last. They were arguing. Pollock's view was that if you make a, or rather like if you make a contract for the tailor to make a suit, you are not simply betting whether he will do it. You want a suit. So you got the two threads in certainly Anglo-American contract jurisprudence going back 150 years or so.
Okay, thank you very much. In my article, I wrote about the distinction also in the United States between Judge Holmes and other scholars about it, and I think it's true. The same thing I wrote here, it's the same conflict that Judge Holmes and other scholars wrote. On your question, okay, this is a big question. What duty to act can be a source of a duty to convict in manslaughter? Not every duty to act can be a source for convicting manslaughter. In Israel, we have a bad Samaritan law. In United States, not all of the countries have these laws. And in France, they have. And if someone breached this law, he can be convicted for 5 years. In Israel, it's only penalty. But there is a question, what if someone beats this law and someone dies because of this. Most of the judges in Israel thinks that it can't be a source of the duty to act for manslaughter. It can't be, but there is an opinion also in Israel that you can be convicted with manslaughter also because of breaching Samaritan law. About the contract as a duty to act, I think this is all over the world. It can be a source of a duty to act. What I have said, what I wrote in my article is to ask why. Why? If it's not enforceable in contract law, can it be enforceable in criminal law? So this is a dilemma.
I'd just like to leave you with a question. If you are a law student, you're graduated, you go into practice, and a client comes to you and says, I want to retain you as an independent lawyer because I'm going to deal with a corporate fiduciary. I want you to be protecting my interests and make sure that I'm not being subjected to. And you're saying to yourself, that corporate fiduciary is the mainstay client of our firm. And if I say too much, they'll withdraw us from their favored client list, and we'll stop getting business. Our firm will go down the drain. That's a very practical kind of problem that is faced. And the other one, how do you square the idea that people who have not read the contract are still held to its terms in spite of the fact that the circumstances surrounding it would make it likely impossible to sit down at that moment and study it, and they're lay people anyway, so they wouldn't understand the gobbledygook.
I would like to thank our panelists for joining us today. We have refreshments in Convocation Hall, and then we have our last panel at 3:45. Thank you. Absolutely.